Okay, I call this meeting to order. As you can see, our usual chair is not here, but I'm assured he's going to be back for the second hour, so I'll try not to mess things up too much in his absence. So welcome to meeting number 32 of the House of Commons Standing Committee on Justice and Human Rights, pursuant to Standing Order 1082 and the motion adopted on September 22nd. The committee is meeting to begin its study of the subject matter of Bill C-28, an act to amend the Criminal Code, self-induced extreme intoxication. Today's meeting is taking place in a hybrid format pursuant to the House Order of June 23, 2022. Members are attending in person in the room and remotely using Zoom. I would like to make a few comments for the benefit of witnesses and members. Please wait until I recognize you by name before speaking. For those participating by video conference, click on the microphone icon to activate your mic, and please mute yourself when you are not speaking. Interpretation for those on Zoom, you have a choice at the bottom of your screen for either floor, English, or French. For those in the room, you can use the earpiece and select the desired channel. A reminder that all comments should be addressed through the chair. For members in the room, if you wish to speak, raise your hand. For members on Zoom, please use the raised hand function. The clerk and I will manage the speaking order as best we can, and we appreciate your patience and understanding in this regard. So we will begin. Welcome to our...
Mr. Chair, before we begin, if I may, I simply want to make sure that the people joining us by Zoom have been tested. Have the microphones been tested as we should be doing? Yes. Very good then. And all is working, I presume, because I think that must be mentioned at the beginning of every meeting to ensure that our interpreters are assured of having a quality of sound that's acceptable to provide translation into French. Thank you.
So all of our witnesses, just if you have any questions, just let us know. But those appearing remotely, just you can select English, French, or floor. And those of you here, you have your earpiece, and you can select your language. So if we're good, we will begin. I'd like to welcome our first witness from the Native Women's Association of Canada, Carol McBride, who's the president, and Adam Bond, manager of legal services. And you have 5 minutes for your opening remarks.
Good afternoon, honorable committee members. I will begin my remarks by acknowledging that we are gathered on unceded, unsurrendered territory of the Anishinaabe Algonquin Nation, my homeland. NWAC takes two key positions on Bill C-28. Firstly, Parliament must address systemic factors that contribute to Indigenous women's substance misuse and Indigenous women's over-incarceration rates. Secondly, Indigenous victims of violence must have easy access to gender-specific recovery services that align with Indigenous approaches to healing. As you know, honorable committee members, on May 13, 2022, the Supreme Court of Canada struck down the Criminal Code limitation on the defense of self-induced intoxication. As a national Indigenous organization representing Indigenous women, girls, two-spirit, transgender, and gender-diverse people, NWAC's criminal reform advocacy seeks to eliminate Indigenous over-incarceration and prevent systemic factors contributing to violence. As Bill C-28 engages the areas of concern, NWAC offers this brief statement to clarify its position. According to the last report tabled to Parliament from the Correctional Investigator of Canada, Dr. Zinger, women represent about 50% of federally incarcerated women, despite representing only 4.9% of the adult population. This crisis demonstrates the links between colonization, systemic discrimination, and intergenerational trauma. The genocide findings in the missing and murdered Indigenous women and girls final report unpacks and explains these systemic factors. NWAC is invested in ensuring victims can access Indigenous justice and healing supports and services. These supports must align with the community's Indigenous legal order in the importance to ensure community-driven, gender-specific healing and support services are sustainably funded and available to violence victims. In addition to addressing victims' healing, NWAC emphasizes a harm reduction and prevention framework. Canada's criminal justice system is largely inattentive to the role substance misuse plays in bringing Indigenous women, girls, and gender-diverse people into contact with the criminal law system as offenders or victims or both. This failure perpetuates substance misuse cycles and over-incarcerations. Honorable Committee, please also recognize that according to Bill C-28, when self-induced intoxication defense is successfully applied, no one is held responsible for the harm, but the victim continues to suffer. Indigenous women, girls, two-spirit, transgender, and gender-diverse people face a disproportionate likelihood of being victims to violence. In some cases, this violence will perpetuate by someone acting under the influence of extreme intoxication. Redressing systemic harms built into criminal justice system requires understanding the difference between Indigenous justice and healing and Canada's criminal law framework. Indigenous legal framework engage principles favoring healing, rehabilitation, elder mediation, and restorative justice. Indigenous justice and healing models require women, girls, and two-gender spirit, transgender, and gender-diverse people who become violent victims undergo healing and receive support predicated on Indigenous understandings of these concepts. Reconciliation principles require creating legal space for Indigenous healing and justice. Thank you, Miigwech. Merci.
Okay, thank you. And now for 5 minutes, and I should mention for everyone, I'll put up a 30-second card if you're got 30 seconds left, and then this one means that you're out of time. But our witness was right on time, so thank you for that. And next we have from Mothers Against Drunk Driving, MAD Canada, Eric Dumchat, Legal Director, and he's appearing by way of video conference.
Thank you, Mr. Chair and members of the committee for this opportunity to speak with you about Bill C-28. My name is Eric Dumchat, and I'm the Legal Director for Mothers Against Drunk Driving Canada, or as it's more colloquially known, MAD Canada. I'm pleased to have this opportunity to speak with you today about this topic, as it is one that I know has caused many of our members some confusion. Simply put, MAD Canada cannot provide an opinion on this bill because it does not affect impaired driving. When the Supreme Court of Canada decision in May of this year effectively allowed for the use of extreme intoxication as a defense for certain violent crimes, MAD Canada heard from many members of the public. While the defense could only be used in very limited circumstances, there was widespread public discussion and fears that those charged with impaired driving or with numerous other criminal code offenses could now use voluntary extreme intoxication as a defense to escape responsibility and accountability for their actions. But with respect to impaired driving, we assured concerned citizens at the time that the ruling would not impact impaired driving cases. And this is because impairment is the essence of an impaired driving offense, where it is not for other crimes such as assault. In short, voluntary self-induced extreme intoxication is not a defense for impaired driving. In R.N. Brown, at paragraphs 66 and 78, the Supreme Court noted that Parliament can constitutionally preclude intoxication as a defense if it is the gravamen of the offense. And then later, the Crown is mistaken when it draws an analogy between impaired driving offenses in section 33.1. The gravamen of the offense faced by Mr. Brown does not include intoxication, unlike criminal offenses for impaired driving. Counsel for Mr. Sullivan made the point plainly. The gravamen of assault is not intoxication. Without intoxication, every element of an assault must be proven. Without intoxication, driving is benign. This case did nothing to change the inapplicability of this defense in the impaired driving context, and as such, Mad Canada was satisfied that the May Supreme Court ruling on extreme intoxication as defense would not impact cases of impaired driving. I thank the committee for its time and would be happy to answer any questions once we have question period. Thank you.
Okay, thank you to our witness. And next and finally, we have for 5 minutes the London Abused Women's Centre, Jennifer Dunn, Executive Director, appearing by way of video conference.
Thank you, and thank you to the committee for inviting me here today. It's very nice to see you all again. My name is Jennifer Dunn, and I am the Executive Director of the London Abused Women's Centre, or LOC, here in London, Ontario. LOC is a feminist organization that supports and advocates for personal, social, and systemic change directed at ending male violence against women and girls. LOC is a non-residential agency that provides women and girls over the age of 12 who have been abused, assaulted, exploited, trafficked, or experienced non-state torture with immediate access to long-term trauma-informed, woman-centered counseling, advocacy, and support. In June, Justice Minister David Lametti tabled Bill C-28. This bill was introduced in response to the Supreme Court Canada decision striking the section of the Criminal Code of Canada, which left a huge hole for extreme intoxication when it plays a part in a violent offense against another person. Evidence shows this type of offense most frequently occurs by men against women. The London Abused Women's Centre believes the Supreme Court has made a mistake. We agree that Parliament had to act in response to the Supreme Court decision, but we do feel it was rushed. There was a lack of consultation before the bill was introduced. In August, MP Karen Vecchio held a virtual roundtable about Bill C-28 at the London Abused Women's Centre. MP Larry Bruck was also in attendance. We had a table filled with frontline workers and women with lived experience. During this roundtable, my colleague, Kelsey Morris, said, "It's incredibly infuriating. We have seen intoxication used against victims and survivors for eons. Intoxication has continuously been used as something to villainize and condemn survivors, and now we are all watching in real time as this same vessel of intoxication is being used to protect and excuse perpetrators. If this defense becomes prominent, as women, we've got the message loud and clear that we are not safe in Canada." During this roundtable, women with lived experience said to us that they are concerned about the Supreme Court's priorities. One woman mentioned protecting the victim should come first. Women should always be a priority. Women said, people who haven't been through this can't possibly understand. They said, you can't ask survivors who have been failed time and time again to trust that this is not going to make things worse. Women have lived through situations where they have been told certain things are unlikely to happen, and then they have had to end up living through those situations in the criminal justice system. On June 23rd, it was said, quote, "The Government of Canada will continue to take action to maintain public confidence in the criminal justice system and support victims and survivors of crime. This legislation is one of several recent legislative reforms and programs the government has advanced to support victims and survivors of crime, including survivors of sexual assault." End quote. During our roundtable in August, one woman made an important point about the fact that extreme intoxication defense might be rare because these types of cases are not making it that far. We know from Statistics Canada that only 6% of sexual assault cases are reported to police. Only 6%. And of those 6%, only 1 in 5 results in a trial. Even before a case goes to court, survivors face complex barriers to reporting. The criminal justice system is largely based on testimony and evidence, which is not effective to those harmed. The extreme intoxication defense creates additional challenges. The London Abused Women's Centre believes this decision by the Supreme Court of Canada was made to favor the criminal instead of the victim. The Supreme Court's decision has left a huge hole. The extreme intoxication defense can be seen as excusing the offender's actions, can show a failure to hold offenders accountable and can be seen as minimizing violent crimes and upholds even some myths about rape. Women call us every day for support. When our community found out about this, women called us and asked how this was going to hurt them. They asked us what they should do next. Women report that they are fearful that perpetrators, mostly men, might automatically think that they will not be held responsible if they are intoxicated. In conclusion, we know Bill C-28 is an attempt to address the Supreme Court's decision around extreme intoxication, aims to support victims and survivors of crime, and to hold offenders accountable. But at the end of the day, the ruling from the Supreme Court truly diminishes all past victories that protect women and girls. Thank you.
Thank you. Thank you to all of our witnesses for their opening statements. I didn't get to use my cards at all, but we will now turn to question and answer time. And the first round is for 6 minutes each, beginning with Mr. Caputo.
Thank you, Mr. Chair. I want to thank each and every one of our witnesses, both present and virtually. What you have to say here is important. And it's not only important, it is necessary, and it's necessary that we get this right. I don't mean to take up the witness's time, but I was particularly struck by your comments, Ms. Dunn, from what you just said. Because it was very striking on so many levels. You spoke about myths, and the first thing that came to my mind was the ability of somebody who commits a sexual assault, an offense that is intrinsically violent in and of itself, that the person could claim to be so drunk as to not know what they're doing and yet still claim that defense, something that I've never really understood. So I understand, and frankly, one of the questions, and the first question I was answered by Ms. Dunn, but I invite everybody to talk about this, and that was the consultations that took place. If any of the witnesses and all of the witnesses want to discuss both personally and their sense of generally whether sufficient consultations have occurred in this process.
So we were consulted. It wasn't a great deal of consultation. I think we understand that the government was under a lot of pressure, that there was some misunderstandings about what the SEC decision meant, and that there was a concern that the public was under the impression that becoming intoxicated was essentially a get-out-of-jail-free card. That said, we would have preferred to have been consulted more and earlier on in the process. By the time we were reached out to, I think that the decisions with the direction of the bill had already been made.
Can I just follow up on that, sir? It sounds, obviously, you said you preferred that the consultations had been a greater extent. What actually were the consultations?
We had a meeting with Department of Justice where they had invited us to discuss the legislation. They invited us to provide their input, and they had explained to us the processes that they had gone through before that point, consulting other stakeholders.
Okay. Thank you. Do any of the other witnesses wish to weigh in on this, please?
I can say something. I think it was clear in my presentation that we had a round table in August, so that by way of knowing it was in August, it was after everything was already complete. We were not consulted ahead of time at all. Thank you.
Can I just follow up on that answer, please? Is your sense, and just my sense is that you're probably fairly plugged into to people who work in the field as well. Can you comment on generally the feeling in the community whether there were sufficient consultations on this very important topic?
Thank you for the question. I have to say that I have not heard in our community of any of the organizations that we work with being consulted. But that's not to say it didn't happen, but it is concerning that we wouldn't know based on the work that we all do together.
Am I good on time? Okay. Last thing, I'd like to the representative from Mad Canada. Thank you for being here. I know you've been very clear that you may not have as much to add to the conversation, but in about 30 seconds, can you just tell us about the feedback that you got from the public on this point? Just the general feedback.
Yeah, sure. Thank you for the question. So we had a lot of confusion, a lot of questions, not only from our members, but, because we are one of the bigger names in the anti-impaired driving scene from the media, is this going to mean that people, can claim I can't be charged with driving impaired, I was too impaired. We got a few questions about that. It was pretty quickly dealt with, just because, as I said in my opening remarks, it doesn't affect us. So we put out a blast to our membership, and I know I gave an interview to at least one media thing, but how much further it goes beyond that, I couldn't tell you.
Okay, thank you. And next we have Madame Bière for 6 minutes.
Thank you, Mr. Vice Chair. Merci beaucoup à tous les témoins.
Thank you so much for all the witnesses for your testimony and for having joined us here this afternoon. We had put forward C-28 after, as you know, the decision handed down by the Supreme Court of Canada, which a decision made in May. In June, Minister Lametti tabled this bill. That was quite quick. We received a letter from our colleagues asking us to move quickly, so we were pleased to be able to work quickly. But for everyone's benefit here today, I would like to hear your opinions about a definition of self-induced extreme intoxication, just so that we can all start from the same basis. So the question is to all three of you. What is self-induced extreme intoxication to you? And perhaps you could begin, Ms. Dunn.
Thank you very much. So it is our understanding that extreme intoxication, when seen in this way, would be where it wouldn't be just one intoxicating substance. So, for example, you could not just have consumed alcohol, for example. It would have to be perhaps maybe a combination of intoxicating substances that could cause extreme intoxication. Further to that, there would have to be reason to believe that the intoxicating substances would create, if you will, an extenuating circumstance for an individual as well. We believe, however, that an individual would have to know that they would be taking the intoxicating substances to begin with, whether it's alcohol or drugs, which would cause the problem to begin with, which I know that in part does not answer your question, but that's basically the understanding of it. We know that this is not a matter of an individual having a couple of drinks and then being able to claim that they were drunk and committed sexual assault. We know that that is definitely not the case. But do people on the ground know that? Not easily. They do not know that right off the top of the bat when they hear about these types of conversations, and that is our one of our biggest concerns. Thank you.
Mrs. McBride or Mr. Bond, would you like to add something?
Yeah. So I'm not entirely sure if I understand the question, but I think it's what is self-induced extreme intoxication in this context. So the bill does spell it out for us. It's subsection 4 that it's means intoxication that renders a person unaware of or incapable of consciously controlling their behavior. I'll avoid a discussion of hard determinism and, the ability to control our behavior. But I think that this has to be situated in the context of the other negligence provisions, essentially, that have been included in here. And so this is in the context, this rendering the person incapable of consciously controlling their behavior is in the context of somebody who has, as Ms. Dunn pointed out, ingested an intoxicant. And this is in the context of somebody who's departed markedly from the standard of care. So, this raises a lot of questions. What is the standard of care of a reasonable person in these circumstances? And I think that these questions have to go by a case-by-case kind of basis. We also have the element of the reasonable person, the foreseeability of the harm, these kind of negligence elements that have been included. So, for instance, in the Brown decision, in the Brown case, we were talking about somebody who ingested magic mushrooms and that they, essentially had no control. And the question is, would this have been captured in this clause? Is it reasonable for a person to know what their behavior would be when taking those types of illegal drugs? At a reasonable standard, is that something? So some people, in some cases, that have a history of certain types of abuses, interference with bodily harm, in those circumstances, they should be aware that a reasonable person, that they're likely to engage in this kind of behavior. But when people take intoxicants that are illegal, it's not like we go to the pharmacy and we see what the potential side effects are. So the question of whether or not something is foreseeable probably has to go to a case-by-case basis.
Thank you. Would you like to add something, Mr. Damsgaard?
Unfortunately, I don't feel that I'm in a position to be able to add anything. As I mentioned, it doesn't really affect impaired driving, and so I have not taken the time to educate myself to a point where I feel that I could comfortably speak on this topic.
Thank you, Madam Briere. Next, for 6 minutes, we will move on to Mr. Fortin.
Merci, Monsieur le Président.
Thank you, Mr. Chair. Thank you to all the witnesses with us today. This is indeed a very important topic. It's one of concern for Canadians across the country, in Quebec, of course, as well. This matter of crimes committed, then people saying that they were intoxicated, self-induced extreme intoxication as a defense. So you are all telling us, if I'm right on this, that you were not consulted before this bill was drawn up. I would like to know, Mr. Domkat, for example, from MAD, if you had been consulted prior to the writing up of this bill, what would you have told the Minister of Justice about this bill? What would you have suggested as a response to the Supreme Court's decision?
To be honest, if we had been consulted, I would have been surprised that we were. As I've said a few times now, this doesn't affect impaired driving. So it would be understandable that we would not be consulted on this because, frankly, there would be no need to consult us on this.
Mais, Monsieur Domkat, vous savez...
Yes, but Mr. Domkat, you're fully aware that people will have vehicle accidents intoxicated, so much so that they won't be knowing what they're doing and that they might well claim a defense, self-induced extreme intoxication, self-induced. So aren't there situations where this might come into play?
This won't come into play. The Supreme Court has upheld the fact that Parliament can create criminal offences where the gravamen, the very essence of it, is impairment. So, if someone were to say, Your Honor, I can't be held responsible for driving while impaired, I was too impaired, that doesn't make any sense. And the case law on this is pretty clear.
Merci. Madame,
Thank you. Madam Dunn, Ms. Dunn, same question for you then. In your opinion, had you been consulted? You, too, said that you weren't consulted. What would you have told the Minister of Justice about this bill?
Thank you very much for the question. So if you're correct, we were not consulted ahead of time, and with regards to this bill, we know that it's truly an attempt to obviously address the Supreme Court's decision, and it attempts to support victims and survivors of crime and hold offenders accountable. But the issue is there was a reason why this was put in place to begin with. I think the year was 1994, if I remember correctly. And this decision really reopens that gap again, and it leaves women vulnerable to crimes. To be honest with you, what we would have said was this decision shouldn't have been reversed to begin with, or taken away to begin with. We should still be able to know that women and girls can be protected without the potential for somebody to have self-induced intoxication used as a defense.
oui, je comprends que vous n'êtes pas d'accord avec les décisions.
Yes, I do understand that you don't agree with the Supreme Court decision, but given that it is a Supreme Court decision, unfortunately, we need to work with it. I certainly don't intend to defend the minister necessarily, but I am wondering what the best response will be, given that we must make do with the Brown decision. What's the best approach? What should the government, should it have done? We have a proposal here. You say you weren't consulted, and that seems to be the case for all the organizations here today. But my concern is to hear what should have been done had you been consulted before this was drafted. Are there parts of the bill that should be dropped? Should something have been added to this? What's your opinion?
I think it would be important to make sure, and I know that this is something that is supposed to be done, but to make sure that the gender-based analysis lens was looked at, or was used to look at this bill as well. I'm unsure if the committee has information on that piece. I think that would be an important step. And I think, speaking to that, it would be very important it would have been very important during consultation time to listen to women with lived experience as well. So some of the women that we spoke with during the roundtable gave some pretty good input on how they feel about this situation. And so sometimes things as easy as education, for example, to let people know what this means in the real world. Because to be honest with you, when we receive phone calls from women saying that, well, what's going to happen to them? What happens next to them? And people on the ground don't particularly know what is going on. That's a huge problem for us, right? So a public education piece would have been vital, I think, in this circumstance.
Okay, thank you.
Thank you.
Thank you, Mr. Fortin. For 6 minutes, next we have Mr. Garrison.
Thank you very much, Mr. Chair. And I do want to start off by saying I think some of us around the table have sort of forgotten the situation that we were in and asking about why people weren't consulted. So the Supreme Court made a decision which created a gap in the criminal law and also created a lot of confusion in the public. And so I think the consensus among all the parties was among ourselves that we needed to act quickly and that these sessions that we're holding now were planned at the time because we knew the consultations couldn't really take place fully unless we were going to leave that gap for months. after the Supreme Court decision. So I think that's kind of been forgotten here, that we really are endeavoring to do those consultations at this point because of the time frame we were forced into. I want to thank the representative from MAD for being here. He's in a peculiar position of providing a kind of negative evidence, but I think it's important that MAD was here today to say that, because I think we still have some of that confusion out in the public that this decision has somehow affected impaired driving. So really, I know it's an awkward position for you to be here today saying it doesn't affect what we're concerned about, but I think that's an important message for us to get out to the public again, that it doesn't change anything about impaired driving. So with that very long preamble, I'd like to ask the Native Women's Association of Canada about what we actually did in the bill and whether you think it's sufficient. So in common language, I think we did two things. We set a very high standard for what it means to be in extreme intoxication, basically automatism, that you're not in control anymore, and we required that evidence be presented of that, not just a claim, but evidence be presented of that state. And the second thing we did is we said that then prosecutors can evaluate whether the care was taken of a reasonable person. So given the Supreme Court decision, I guess what I'm really interested in today is this a good thing that we've done here, and is it a sufficient thing that we've done here?
I will try to be as brief as I can.
Take your time.
So, is it a good thing that we've done here? I think that there were essentially two options that were available, and both of them resulted in the same outcome, right? The court had basically said standalone offense or fix 33.1 for reasons that I think were echoed in the consultations through the 1990s on this with women's groups, the risk that a standalone offense could undermine other types of like plea deals, and somebody could commit sexual assault and then plea out to a lesser offense of extreme intoxication with whatever. And this option of tightening it up, including these negligent standards. At the end of the day, we don't know if either of these options are really going to be successful in addressing what it was at the core of Brown, which is the substitution of the mens rea for becoming intoxicated with the mens rea to commit the offense. Does it do it? We will find out, I'm sure, one day. Is it good? I think it was good that action was taken quickly. We should have been consulted earlier. We would have liked to have a conversation, even if there were only two options and both of those options kind of ended at the same place. When we did consult, or when we did have the conversations with Justice, our position was, as my president set out here, the bill cannot be enough. These are systemic issues, and they cannot be dealt with by fixing the criminal code. They cannot be dealt with in the criminal code itself. The reason that we have this provision to try and deny the application of a defense of self-induced intoxication is because we have problems with extreme intoxication, with misuse of substances. And these problems are pronounced in marginalized communities, including Indigenous communities, because of the legacies of systemic racism, because of colonization. And what we need is not just amendments to the criminal code. We need more substantive policies and programs to address the underlying issues. If we get ahead of extreme intoxication, it won't be an issue. If nobody commits the crimes because of the extreme intoxication, then we don't need 33.1. So we need to focus more on the peripheral policies and programs to address these underlying issues, because it doesn't matter what you do. Nothing's going to be enough in the criminal code alone.
Thank you. I think that's very important testimony for the committee to hear and to think about when we're reporting back to Parliament at the end of this. I know there's not going to be very much time, but I'd like to ask Ms. Dunn the same. Maybe I won't ask Ms. Dunn this time. I'll ask on another round. Let me just stay with the Native Women's Association of Canada then. I know the answer to this, but do you see ways that we could actually increase the support services at the community level to help deal with those addiction problems that lead to extreme intoxication?
Well, I definitely don't have enough time for that one, but I would just say it needs to be done at a community level and a nation-to-nation level, because we can't paint with too wide of brushes. We need to understand that the communities and the organizations are in the best position to explain what services and supports they need.
Thank you very much. Oh.
Next, we will go for, Mr. Garrison's time is all up, so, but there'll be other opportunities for sure. Next, for 5 minutes, we'll go to Mr. Van Popta.
Good. Thank you very much, Mr. Chair, and thank you to all the witnesses for being here and sharing your wisdom with us. This is a very important study. Ms. Dunn, I want to focus on you at first. Thank you for the important work that you do in helping women who are the victims of crime. So today we're talking about whether or not extreme intoxication can be a defense for a person accused of a violent crime. And this is you're a very important witness for us, Ms. Dunn, because to quote the Minister of Justice when he introduced this legislation, and I quote, "We know that there are clear links between intoxication and gender-based violence, particularly sexual violence and intimate partner violence." He goes on to say that 63% of women and girls who were killed by an intoxicated attacker, close quote. Now, in your earlier evidence, it was clear that you did not agree with the Supreme Court of Canada's decision in R versus Brown, which reintroduced that defense into Canadian jurisprudence. But my question is whether, in your opinion, there is ever a possibility that that defense should be available, reasonably available. I'm going to take the facts in the Brown case. He had consumed alcohol and magic mushrooms. And he said in evidence that he did not know what the impact of that was going to be. He could not reasonably have foreseen that he would lose control over his ability to know what he was doing. So in those circumstances, would it be reasonable for that defense to be available?
Thank you very much for the question. I appreciate the opportunity. So this is interesting because being asked if this defense should be available in other situations is a good question for us, because it all goes down to the systemic issues that we have at hand here. I mean, I would like to say that, you know, the majority of people who commit sexual assault, for example, are men. So I would like to suggest, you know, it's these types of situations with these men, should that type of defense be available? Absolutely not. Right? Because the women are at most risk in this type of situation. But in other types of situations, it would be easy to say, you know, there was, you know, a woman who, let's just say the exact example that you just gave, but in a woman, and we would say, well, let's think about that. There should be perhaps more opportunities for this person. They should be able to use extreme intoxication as a defense. And then it comes down to this big systemic issue that we have at play here, in the fact that these laws are not being looked at through the lens of violence against women. And so I think it would be really important to think about, how do we protect women in this situation? How do we protect specifically Indigenous women, racialized women, and what does that look like? I don't think it's a matter of will this defense be good in some situation? Will it be a good idea to allow this defense here, but not a good idea to allow it there? Because it's way bigger than that. And yeah, I'm going to put a period at the end of my sentence. There.
Good. Well, thank you. Many Canadians would be very sympathetic to what you just said. But we parliamentarians have the challenge that the Supreme Court of Canada put to us, and we're trying to respond to it. The Supreme Court in the Brown case said that Section 33.1 was unconstitutional. But they did say, if you were to frame a law that, sort of within these these parameters, it might be constitutional. So that's what we're trying to do here. But, your evidence is very useful for us, and thank you for that. I'll concede my time. Thank you. Thank you very much to all the witnesses.
Okay, next for 5 minutes, Ms. Dillon.
Thank you, Mr. Chair. My questions will be mostly for Mrs. McBride. I'd like to start with the question, Bill C-28. People who have committed violent crimes cannot use the defense of voluntary extreme intoxication if they have consumed intoxicants in a negligent manner. What impact do you think this bill will have on Indigenous women, girls, and gender-diverse people, as well as how will it affect their confidence in the justice system?
So what will the impacts be on Indigenous women and girls? It's a little bit of a difficult question. We need to understand that there are two kind of competing interests here. On the one side, we have the over-incarceration of Indigenous women. On the other side, we have the over-representation of Indigenous women and girls being victimized by violent crime. So on the side of, protecting people from violent crime, I think that, this bill is a rapid reaction to the Supreme Court's decision to, I think, primarily address that public misunderstanding about what that decision did and to calm down some of the myths that were spreading relatively rapidly. And I think that that's a good protection, though 33.1 has existed for a long time, and there's still overrepresentation. So it's hard to say. Maybe status quo. As far as making sure addressing the overrepresentation or over-incarceration, again, I don't think it's going to be particularly impactful just on its own. These cases are quite rare. That the 33.1 defenses are made. But I don't think that it will result in more Indigenous women being incarcerated necessarily. Again, as I was saying earlier, the real return on investment for addressing these issues is going to be with the policies and programs. So I think, what are the effects? Likely status quo to pre-Brown decision.
I thank you for your answer. And I'd like to follow up with maybe Mrs. McBride's testimony that NWAC looks for a harm reduction and restorative justice framework. Can you please elaborate how that would unfold and talk a little bit about this model?
First of all, I think we have to take into consideration every First Nation has their own way of dealing with justice issues. And I would see in different situations, different ways of healing. I know for NWAC, right now we're looking at resiliency lodges, which I think is going to help our women that are going through different situations in their life, and hoping that we can give them the help that they need before going to this extreme measures of an extreme intoxication. I think it all depends on the First Nation, and it should be up to the First Nation to put in these healing mechanisms, because I think that's where the problems are going to be ironed out a little bit or solved a bit more than what they are now. Right now, First Nation communities the Métis and the Inuit. We just don't have the money to be able to put in the services that's needed in the community. We are facing big problems, especially with addictions. So anyway, that's, I hope that enlightens you a little bit on what's going on in our Indigenous communities.
It does, and I thank you so much for your very frank response. I think my time is up.
Dylan, and next for 2.5-minute rounds, Mr. Fortin.
Merci, Monsieur le Président.
Thank you, Mr. Chair. I would like to go back to what I was saying earlier, perhaps to you, Mr. Bond. I understand from your testimony, and perhaps I misunderstood, please correct me if I'm wrong, but that a Bill C-28 is suitable to you, it's an acceptable response to the Supreme Court's decision in the Brown matter, but that you would prefer that we keep to the status quo prior to Brown, which of course isn't possible. Unfortunately, we're not in fairyland, and we must somehow manage with the Supreme Court's decision. So I understand that the bill, as it is relatively acceptable to you. And if not, could you tell me what section, what clauses, what provisions should be changed, and how they should be changed? You've only got a minute, I'm sorry.
Well, I don't think I said that the status quo was acceptable to me. The question was, what was the effect on Indigenous women? I said that the effect was going to be status quo. Whether or not there are things that I would change, I think I answered this. There were two options. Both of those options led to the same outcome. So I think that this bill, in that the purpose of it was to address the kind of public concerns about the Brown decision, is effective in doing that. If it's supposed to actually address the issue of extreme intoxication-related crimes, well, it didn't do that pre-Brown. It's not going to do it after. I think the crux of our comments here is that we need this to be coupled with services and programs to address substance misuse issues.
Donc, si je comprends.
So if I understand correctly now, you have no specific suggestions to make for this specific bill. If we're to report on it later, I understand that you don't have a specific recommendation to change anything here.
Merci. Madame.
Thank you. Ms. Dunn, the same question to you. I'm afraid there's not much time left, perhaps half a minute. Are there any sections of this bill that, to your mind, should be changed, and if so, how?
Thank you very much. I will try to be very quick. Off the top of my head, to be honest with you, I can't tell you specific sections, but I think something important was said by Mr. Bond there. I mean, we need to work hand in hand with this legislation as it is. I know we can't change what has happened from the Supreme Court, but we need to work with organizations and especially women with lived experience to see how this unfolds and what will be best moving forward.
Merci, Madame Dunn.
Thank you, Ms. Dunn.
Mr. Garrison for 2.5 minutes.
Thank you very much, Mr. Chair, and I want to come back to Ms. McBride and ask her. We're talking about a very narrow case here of self-induced extreme intoxication, but we know that many more women, and in particular Indigenous and marginalized women, are subjected to sexual assault. And my question, a kind of leading question, but is what are the services like for Indigenous women who've been subjected to sexual assault? Do you feel the same level of services and the same culturally appropriate services are available to Indigenous women as are available elsewhere in our society?
I find that what we're suffering within our communities is the lack of healing resources that would help our community, our women. We just don't have enough resources, financial resources, to bring in what we need. Our people have been through a lot. Residential school, these people are coming back to a very poor community that can help them with their healing. That's where I think we really have to concentrate on, is bringing those resources to the community. And I think that healing can only happen based on what's within their own culture. How we have our own healing processes. Unfortunately, like I said, we all have poor communities, and we can't, like when you're talking about housing and food and everything else on everyday life, but we just don't have enough to go around. So that's basically what we're hoping for, is that we do get enough resources to be able to help our people, and they don't end up behind bars, and they don't end up being victims, and they don't end up being a woman and have to put up with the violence. We're hoping to get our men healed, or within their healing process, before this happens. But anyway, I hope that helps a bit.
No, I think it's again, it's very important testimony to get the committee to focus on not just the narrow law in front of us, but how we address the problem that results in having to have such a law. So thank you very much for your testimony again. Thank you, Mr. Chair.
Thank you, Mr. Garrison. And I want to thank all of our witnesses, those that appeared here and virtually. We appreciate your input as we study the subject matter of Bill C-28. So I would ask members who are on virtual to use the second link said to you a few minutes ago for the second part of our meeting. That meeting is going to be in camera, and I'll be relinquishing the chair to our real chair at that point. So the second hour of our meeting is in camera, and I want to thank our witnesses, and we appreciate your testimony. I will suspend the meeting for a few minutes.
You did a great job, Mr.
Thank you.